Let's get started with uh, our 11 o'clock panel. The topic that we have been assigned is to discuss the present-day practical consequences of peers. And before introducing our outstanding speakers, I just want to make a couple of comments of my own. And that in particular is that there is one practical consequence that we don't see, and that is we would not see a case like Pierce today. For one thing, as someone mentioned in the previous panel, I can't remember the last time the Supreme Court issued an opinion under 5 pages on anything, let alone something this substantive. And the sort of potential demise of substantive due process was also discussed at some length. But the third thing I wanted to point out is something that has not been mentioned before this, and that is the issue of standing. It looks to me as if the way this case actually was decided, it might be today kicked out on the basis of standing. The school, both schools, the Catholic school and the military academy, brought suit to vindicate the rights of parents, none of whom were parties to the case. And the court used completely non-economic reasons relating to the parents to decide a case that was brought on economic grounds by the schools. So I think that would not happen today. However, our speakers are going to be talking about other consequences, and I would like to introduce them briefly, starting at the far end, coming this way. And that's also the order in which they will make their presentations. Michael Bindus is a senior attorney with the Institute for Justice. He argued Carson versus Macon at the Supreme Court, securing a ruling that Maine's exclusion of religious options from its educational choice program violated the Free Exercise Clause. Previously, Michael worked at Perkins Coie. He attended West Point and the University of Pennsylvania Law School. Eric Hanashek, the Paul and Jean Hanna Senior Fellow at the Hoover Institution here at Stanford, approaches the topic from a policy perspective. A prolific author, he is recognized internationally for his economic analysis of educational issues. Rick is a distinguished graduate of the Air Force Academy and holds a PhD in economics from MIT. Sitting next to me, Zalman Rothschild is an assistant professor of law at the Benjamin Cardozo School of Law. He holds a JD from Harvard Law School and a PhD in religion from NYU. Previously, he was a Bigelow Fellow at the University of Chicago Law School and a litigator at Paul Weiss. His research focuses on the First Amendment, anti-discrimination law and religion. So, Michael, please start us off.
Sure. I just learned that, Eric, you went to the Air Force Academy, so I'll start off by saying beat Air Force. Could be worse. You could have gone to Navy. But
Watch it.
Well, thank you, Judge McConnell, for inviting me to this. I feel like a bit of a fraud here. I think I'm the lone practitioner here. I'm not an academic. I know Eric has a foot in both doors, or in both fields, but I am a litigator exclusively, and I advocate for and defend school choice programs across the country. These are voucher programs, education savings account programs. I know that there was some discussion of education savings accounts yesterday. These are simply scholarships like vouchers that can be used on a broader array of educational expenses. So yes, they can be used for private school tuition, but they can be used to pay tuition to attend an out-of-district public school, or to for expenses incurred in homeschooling your child, or to hire private tutors or special education therapies. So like vouchers, but with a much broader array of permissible education uses. Surprisingly, Pierce and Meyer have played very little role in the litigation surrounding these programs, at least to date. Pierce and Meyer certainly discussed in the legislative debates when legislatures are considering adopting these programs. I think legislators correctly see themselves as adopting these programs to empower parents to exercise the rights recognized in Meyer and Pierce. And it comes up as context in the litigation, but almost never does the litigation turn on Pierce and Meyer. Why? I mean, that seems kind of odd if these programs are all about empowering the rights recognized. Why does the litigation not turn on that? And that is because for the 30 years plus that we've been litigating school choice cases, the arguments have turned primarily on religion, right? School choice opponents argued first that school choice programs are unconstitutional under the Establishment Clause because they allow religious schools to participate. The Supreme Court roundly rejects that argument in 2002 in Zellman versus Simmons Harris and says, look, so long as the program is neutral toward religion, meaning religious and non-religious schools alike can participate, and so long as the program operates on private, independent choice of parents, they're perfectly permissible. Opponents of school choice don't pack up and go home at that point. They retrain their focus to state Blaine amendments. These are provisions in state constitutions that, generally speaking, prohibit public funding of religious schools. And they argue, well, it doesn't matter if school choice is permissible under the Establishment Clause, it still violates our state Blaine amendments. And so they begin attacking school choice programs on that ground. And thankfully, in a pair of opinions in 2020 and 2022, the Supreme Court rejects those arguments. It says, basically, to apply state law, whether it's a Blaine amendment, as was the case in Espinoza versus Montana Department of Revenue, or a state statute in the case of Carson versus Macon, to apply state law to exclude parents and children from an otherwise available education benefit program because they choose religious schools would violate the Free Exercise Clause of the United States Constitution. So with those decisions from Zellman through Carson, the religion questions have been largely resolved. I mean, there's still some issues. There's the charter issue that's being litigated right now. But for the most part, in kind of conventional school choice programs, religion is off the table now. The religion wars are, for the most part, over. But the fight against school choice is not. School choice opponents are a dogged bunch. They continue their attacks, but they're shifting their focus away from the religion issues. And one area that I want to speak about today is what I call public-private Blaine amendments. Several states, a fair number, have Blaine Amendment variants that turn not on the religiosity of private schools, but on the mere fact that they are private schools. So these provisions can operate in a couple of ways. One is to prohibit public funding of private schools, or in some cases, you see language prohibiting public funding of schools not under the absolute or the exclusive control of the state. So, just by way of example, Alaska's public-private Blaine Amendment prohibits the use of public funds for the direct benefit of any religious or other private educational institution. Opponents of school choice are now weaponizing these public-private Blaine amendments much the same way that they previously weaponized the more conventional religious, non-religious Blaine amendments. And in fact, they're doing that in several states right now, but I'll talk about Alaska because that's where this issue is kind of most directly coming up in litigation right now. So the legislature in Alaska has adopted what operates similar to an education savings account program. It's called an allotment program, but basically it gives parents in Alaska an allotment that they can use on a wide variety of educational expenses for their children. Yes, it can be private school tuition, but it can be homeschool related expenses, textbooks, curricular materials, tutoring services, school supplies, technology, a broad range of educational expenses. In 2023, a group of plaintiffs funded by the State Teachers Union challenged this allotment program under Alaska's public-private Blaine Amendment because one of the permissible uses was private school tuition. And of course, as I read just a little while ago, Alaska's constitution prohibits public funding for the benefit of private educational institutions. Now, Carson and Espinoza don't resolve this case, right? Because they turn on this religion, non-religion distinction, and here we have a public-private distinction. But this is where Pierce comes in. The U.S. Supreme Court has repeatedly referred to the right in Pierce, that is the right to direct the education of your children, including specifically to send your child to a private school, as a fundamental right, just like the free exercise of religion. So that raises the question, can a state constitution be used to deny an education benefit simply because some parents use that benefit to exercise that very fundamental right to send their child to a private school. By barring aid to private school students, these public-private Blaine amendments condition the availability of education benefits, public education benefits, on a parent's surrender of her fundamental constitutional right to send her child to a private school, much the same way that Montana and Maine and Espinoza and Carson condition the availability of education benefits on the surrender of a parent's fundamental right to choose a specifically religious school. The Supreme Court has repeatedly held in many contexts that a state cannot condition the availability of public benefits on a citizen's surrender of a constitutional right, nor may it penalize a citizen because she has exercised such a right. But that's exactly what these public-private Blaine amendments do. They bar education benefits for children whose parents exercise the very right recognized in Pierce. Remember, in Alaska and in other states with education savings accounts programs, the state can fund anything else, right? Homeschooling, tutoring, special education therapies, extracurriculars. But the plaintiffs in Alaska are arguing that while they may be able to do all that, parents cannot use these funds for one thing and one thing only. That is to pay tuition for their child to attend a private school. That's a problem under the Supreme Court's due process, specifically its unconstitutional conditions jurisprudence, but it's also an equal protection problem. Remember Romer versus Evans, right? This is the case where Colorado enacts a state constitutional amendment that targets gay and lesbian citizens and prohibits protections and benefits for gay and lesbian citizens. The Supreme Court invalidates that state constitutional provision under the federal Equal Protection Clause, and it says, central both to the idea of the rule of law and to our own Constitution's guarantee of equal protection is the principle that government and each of its parts remain open on impartial terms to all who seek its assistance. Thus, a law declaring that in general it shall be more difficult for one group of citizens than for all others to seek aid from the government is itself a denial of equal protection in the most literal sense. Again, this is exactly what these public-private Blaine amendments do. They make it more difficult, actually impossible, for one group of citizens than for all others to seek aid from the government. And worse, it defines that one group of citizens based on a single characteristic: their exercise of the fundamental right to choose a private education for their children. So a group of parents that my firm is representing intervened in this Alaska challenge to defend the program, the allotment program, because they currently use it to pay for tuition for their children to attend private schools. Now, to be clear, they're not arguing that the federal Constitution requires a state to provide aid to families who choose private education for their children. The Supreme Court has already held in Espinoza that a state need not fund private education. Rather, they're maintaining that to apply Alaska's Blaine Amendment to deny benefits that the legislature already, in its discretion, has chosen to provide them, including to use this benefit for private school tuition, to deny that benefit based on Alaska's public-private Blaine Amendment violates their federal constitutional rights, just as the application of Montana's Blaine Amendment in Espinoza violated the rights of parents to choose a specifically religious private school for their kids. The fundamental right may be different, right? In Montana, it was the free exercise right to choose a religious school for your child. In Alaska, it's the due process right to choose a private school for your child. But the problem in either case is the same: a state constitution being applied to bar aid to families because they exercise a fundamental right. So what's happened in this case so far? Well, in late 2023, the trial court agreed with the plaintiffs challenging Alaska's allotment program and invalidated the program in its entirety under the public-private Blaine. The trial court did not address the federal constitutional questions that my clients raised, even though they were squarely presented in the litigation. But the Alaska Supreme Court reversed the trial court in June of this past year, It held that the trial court was wrong to invalidate the program in its entirety because there were plenty uses of the allotment program that were perfectly permissible under Alaska's Blaine Amendment, such as homeschooling-related expenses and tutoring, um, uses other than private school tuition. Now, the court did not hold that uh, Alaska's Blaine Amendment barred use of use of the allotment for private school tuition. Rather, it remanded the case back to the trial court to address that more limited question, right? Can the program be used for that particular use? But it also specifically directed the trial court to address the federal constitutional implications of applying Alaska's Blaine in that way. So we're waiting to see what happens with that case. We're in the midst of briefing right now. But this is an issue that is coming up in several other states as well that have these less common but still discriminatory public-private Blaine amendments. So that's one kind of pending issue related to Pierce in the school choice context. One other that I'll just briefly mention is the extent to which Pierce and Meyer apply to protect the rights of education entrepreneurs. We're in a time of incredible innovation in education, right? Things like learning pods, micro schools, hybrid schools that developed largely in response to two things. One, the pandemic and parental frustration with the failure of the public school system during the pandemic, and also the proliferation of education savings accounts, which provide much greater flexibility to engage in these types of education innovations. During the pandemic, these innovations were largely tolerated out of necessity because the public schools were not providing an adequate education, but we're beginning to see some degree of governmental suppression of these innovations, whether it's through private zoning or municipal zoning laws, attempts to saddle micro schools that may educate 5 students with the full regulatory regime that applies to more conventional private schools. Um, and I think you're going to start seeing litigation over these efforts to suppress these education innovations. Um, and I think there's an open question about to what extent do Pierce and Meyer provide these entrepreneurs, these education entrepreneurs? To what extent do they protect their rights? And Judge, I would respectfully disagree with you that Pierce and Meyer didn't concern economic rights or the rights of education providers. They were brought by education providers. That passage at the beginning of Meyer that Dean Post referenced yesterday, that was up on the screen for quite a while, spoke extensively of economic rights, the right to contract, the right to engage in a common occupation. And the court in both Pierce and Meyer, yes, protected the right of parents, but also the economic rights, the contract and property rights of education providers. Robert Meyer, Hill Military Academy, the Holy Name Sisters. Um, in Pierce, the schools, the court noted, have business and property for which they claim protection, and these are threatened with destruction through the unwarranted compulsion which the state is exercising over present and prospective patrons of their schools. The successful conduct of the schools, the court explained, requires long-time contracts with teachers and parents. And even though Oregon's law was not yet being enforced, the court noted that it had, quote, already caused the withdrawal of children who would otherwise continue. Thus, the court concluded, the protection against this arbitrary, unreasonable, and lawful interference with their patrons and the consequent destruction of their business and property was warranted. So I think Pierce was very concerned with economic rights as much as it was with parental liberty, and so too in Meyer. Um, in resolving that case, yes, again, the court focused on the parental rights, but also on Robert Meyer's right to teach, as well as the right of parents to engage him so to instruct their children. So I think it's a mistake to look at Meyer and Pierce exclusively as about parental rights. As I mentioned in my question before, I think the court had a much broader conception of liberty that yes, included the right of parents, but also the right of the Robert Myers, the Holy Name Sisters, the Hill Military Academies to provide education services to families, and the right of families to engage them. So I think that's going to be another very interesting question that we'll see litigation over in the coming years about the extent to which Pierce and Meyer might protect the rights of education entrepreneurs.
Thank you. Eric?
Well, that's a good introduction for what I want to talk about. I'm an economist who comes without any sense of looking at the precedence of cases, the importance of the 14th Amendment or the First Amendment, but in fact come to this looking at issues of educational policy and the way that school choice fits into educational policy. Is it good policy? And then uh, in the end, how litigation fits into school choice and educational policy. Um, so I'll give you my tribe is more interested in outcomes of students and the school impacts on distribution of outcomes and performance. And so I'll talk a little bit about that. I have a simple view of the history of education, and that is that the 20th century was extraordinarily important for what happened in schools. At the beginning of the 20th century, we had 130,000 school districts in the US. We had 4% of the population was getting a high school degree, and a variety of other measures of performance. But I think that over the 20th century, schools did a lot more. They expanded. We had uh, basically much more completion of schooling. We had consolidation of districts that we'll come back to. And I think there was a general good feeling about the way schools operated. We historically have had, I think, since the beginning of the country, a mixture of public schools, private schools, and homeschooling. And then we get down to what's the right balance between those, and how does changing the balance between those affect the outcomes that I think are important in schools. Um, and what we had, as I understand history or think of history of schools in the 20th century, everybody was pretty happy with what was going on in U.S. schools. In fact, we were the leader in the world of schooling, of making public school available to everybody. And no other country in the world was doing it at the time we were. And so people were quite pleased with this. But as the 20th century moved along, we started to have questions about the performance of the public schools. Were they doing a good job? And we had some skepticism about how well schools were doing at educating kids. And this, I think, led to the um, main discussion about school choice was whether school choice would help us to improve the quality of schools that we thought was many people thought was lagging near the end of the 20th century and into the 21st century. Um, let me so my simple conclusion that I won't emphasize here is sort of more of a footnote on how I got into this discussion, is that our schools are in fact behind in a very fundamental sense. Worldwide, we're not doing as well as we should, and that this has long run implications for the US economy, and that it is important for us to improve our schools. And that's how I became sort of a fan of school choice as a potential way of educating a better group of our population. But as I view Pierce, I should add another footnote here. Um, I didn't know about Pierce until I was asked to come to this conference. This is not something that is part of the educational policy discussions. I was missed yesterday because I was at a conference on the economics of education, and I queried all of my other conferees on what they knew about Pierce and its implications for school choice. And I did not find one person who had ever heard of Pierce. So that's the caveat that I come into this with. But as I understand, and as I've not, perhaps naively interpreted Pierce with respect to schools, is that Pierce said that parents and children had a right to school choice and to private schooling, but the state also could have regulations making sure that the schools met what they wanted to get out of the schools. And so that my naive interpretation is that it's a balance between how much regulation we're going to put on choice schools versus the right to have open schools. Um, my my fellow people can discuss my naivete as we go along. But when I look at school choice, and where most of my colleagues do, we generally go back to Milton Friedman and his 1955 article about vouchers, and basically making the case that while the state had an interest in what was going on in schools, there was no reason why we had to think of the state running the schools. You could think of other people providing this interest. In his 55 article and in Capitalism and Freedom, where he lays out some of these in a clearer way, his main thing was just the right to choose. That was the choice option to parents to find the schools that met their interest. Well, what's happened since Milton Friedman and his public book with his wife, Free to Choose, was all about just individual rights and liberties, which has been the discussion in much of this. But the educational policy discussion has taken the other side of Milton Friedman that talked about competition and efficiency and the value of having an alternative to put pressure on the traditional public schools to, in fact, do better. If there's competition and they're going to lose their students because there are better other options, then this would lead the traditional public schools to do a better job. And that's been basically the reform argument that's been made. Well, what's happened in choice, or where does choice stand today? I think Paul Peterson talked a little bit about choice options yesterday and education savings accounts. What we had before the pandemic was basically this situation where we had consolidation of the 130,000 school districts down to 13,000 school districts, which led to some very large central city school districts that have generally been viewed as not being all that high quality on average, and that these central city school districts, in fact, had captured a group of poor and disadvantaged parents and students who couldn't exercise the largest choice option, and that is choosing where you live, the residential choice option. They're sort of stuck in these bad schools. And so the argument was largely for offering more choice to people stuck in bad schools, largely thinking of urban centers. In 1992, the state of Minnesota invented something called charter schools, which was to take public schools and a subset of public schools and give them freedom to do whatever they wanted, in some sense, in terms of pedagogy and the way they operated, free them from lots of regulation, provide them public funding, but free them from the regulation in exchange for a contract that said that they were going to do good. And if they didn't do good, they could in fact lose their contract and would not be able to continue operations, so that they had a requirement to educate people in the way that they said. Uh, Charter schools have become one of the largest parts of choice in the U.S. They went from zero in 1992 to about 1% in 2000 to about 7% of all students today go to charter schools. Matched against that, charter schools, in fact, took away a little bit from the traditional public schools, and they also took away from the traditional private schools, so that Catholic school enrollments went down with charter schools, and total private school and enrollments went down, so it's under 10% today, but around 10% for private schooling, 7% for charter schools, and now about 3%, as best we can tell, for homeschooling. And so you have a 20% of the school population that has these alternative ways of providing schools. Now, what do we know about them? Well, we know the most about charter schools because they're public schools. They participate in testing programs, and we know a lot about their outcomes. What we found is that, at least in recent years, on average, charter schools do a bit better than their comparable traditional public school. We know that there's a wide variation in their performance, in outcomes. There are some really bad charter schools, and there are some really good charter schools. If we look at private schools and what do, we know virtually nothing about them, because they essentially don't participate in any routine testing programs. We know a little bit about Catholic schools in various places, but not very much. We don't know anything about, and we don't know anything about homeschooling, except that the last panel, we had a testimonial about own homeschooling, and we have periodic news reports about how one of the top graduates of Harvard was homeschooled. But we know nothing essentially about the full 3% of these schools. So let me put that into how I would look at that from a Pierce standpoint, as I understand Pierce. There are very widely different regulations that apply to charter schools, to private schools, and the home schools if you look across the states. So if I look at charter schools, for example, there's a set of states out there. You might even be able to guess which ones they are. Arizona, Florida, Indiana, Colorado, that try to make it a good deal to run a charter school and to make it available. They make it easy to get approval for charter schools. They really take away regulations about what the curriculum is, the length of the school year, and so forth. They basically have no cap on the number of charter schools. And then contrasting to that is Maryland and Virginia, Nebraska, Kansas, and some others that we'll mention, that insist that to get a charter, you have to get the approval of your local school district, your competitor. In order to run a charter, you have to certify that you will use the state curriculum and state school year and so forth. And your contract is a very short period of time, as opposed to the other states that say it's 10 years. So we have these widely different regulations for charter schools. We know nothing about their impact on student learning. whether it helps or not. What we do know is that it affects the number of kids in charter schools, but beyond that, we don't know much about does it affect performance. I can say the same thing about homeschooling. In homeschooling, we have a number of states that don't even require school students to register. They can do whatever they want. So we have Texas and Arkansas and Idaho and some others that have very nominal notification requirements. They have no requirements for any testing. They have limited requirements for what might be taught to these kids. They just say, go do it. Then we have other states that New York and Pennsylvania and so forth that require annual notification, annually reporting on what your curriculum is, recording how many hours you spent on each subject, and so forth on down the line. Again, we have these wildly different requirements with no information about whether any of them make any difference, whether anybody learns. And you can go through the same thing with private schools. The story is there, and so for speed, I won't go through them. But private schools have the same set of varied restrictions that lead to litigation, as Michael said, and that's one of my main concerns when I get down to the end. I have never been involved in litigation on these school choice issues, but I've spent a lot of time on a related issue of school finance and litigation in school finance. And from my standpoint, the courts have not improved schools through their litigation and through their judgments in these school finance cases, of which there have been over 200 school finance cases in every state except for Hawaii, which only has one school district, and in Utah. Except for them, every state has had school finance litigation, and there's no evidence that the schools have been helped by the school finance litigation that where the courts try to enter into this. So what I see out of Pierce, and as we expand to vouchers, and by the way, I'm in 20 minutes. In 20 minutes, Texas Governor Greg Abbott will sign a voucher bill of $1 billion into vouchers in the state of Texas, which are open basically to everybody, although the money won't support everybody. And this is part of a recent expansion that I think Paul talked about yesterday of educational savings accounts, which are sort of specialized vouchers in many ways. Charter schools are in some sense vouchers of given kind. And we've had now, I think, 5 states that have things that are actually called vouchers, where we've opened this all up. And what I see from, and is reinforced by Michael's introduction, is that we're going to get all kinds of litigation on how states regulate all of these choice mechanisms, and we're going to have a new round of huge litigation. Maybe everybody in this room is into litigation and likes the idea, but from my standpoint, I see little hope that that actually improves the quality of schools, and that this may, in fact, meet versions of what are the rights of students, but I don't, from an educational policy standpoint, I am most concerned about this. And we're into this area where we have all kinds of regulations and have absolutely no idea of what their impact is.
Thank you.
So I'll end there.
Salman?
Thank you. I think it was Oliver Wendell Holmes who said hard cases make great constitutional law conferences discussions. I think I'm quoting him correctly, and I want to talk about a hard case, a contemporary case, a case that is currently pending in the highest court of New York, a case that's quite similar to Yoder, which we've heard quite a bit about, Wisconsin v. Yoder in the Amish community, which came down roughly 50 years ago in 1972. So it's time for maybe an update, involving the Hasidic community, in New York. And there are lots of Hasidic kids in Hasidic communities in New York. The estimate is that there's about 100,000 children enrolled in Hasidic schools in New York. And there is a difference, I should mention, between the boys' schools and the girls' schools, and there are boys' schools and girls' schools that are segregated. In that the boys' schools in particular provide essentially no secular education. It used to be when I would say this, people would be in disbelief and accuse me of making stuff up and what have you. And then the New York Times did an expose. It was on the front page of the New York Times, and really deep investigative journalism, and corroborated my portrayal of the facts. So some don't believe the New York Times. I can't help you there, if that's your position. But this has been corroborated many times over. It's not just a theory. That the Hasidic schools, at least the boys' schools, provide practically no secular education. Now, what is secular education? Secular education is anything and everything that is not Jewish education. So that includes math and science and English and composition, etc. Some Hasidic schools provide an hour, at most 90 minutes at the very end of the day, taught by a young Hasidic man who himself doesn't really speak much English. And the way it's described by those who have gone through that education system is that it's essentially recess. Others don't teach any at all. They don't even pretend to teach secular education. Girls' schools do provide more secular education, ironically, because in the Hasidic community, girls are not actually permitted to study a lot of the more advanced Jewish studies. And so, okay, they can get the lowly secular education, which can turn out to help them quite a bit if they eventually do decide to leave the community. So there is a difference between boys and girls schools. There isn't much in the way of precedent and case law on this, because talking about, the judge mentioned standing. I mean, you would have a really problematic standing question here as to who would bring the lawsuit, and also more preliminarily, who the law applies to whom does the law apply, the law of compulsory education. And it applies to the parents. So that would mean that children would have to be bringing a lawsuit against their parents, which wouldn't happen. You can't imagine that really happening. The state, of course, could, let's say, prosecute in some way, and then the parents could defend themselves, and it could end up in court. But the state didn't do anything for decades and decades and decades. And that changed about 10 years ago, when the state of New York, the New York State Education Department put out regulations to give some teeth to the compulsory education law in New York, and every state has compulsory education laws. The language in the New York compulsory education law is very similar to many others, which is that, going back to Pierce, that parents must send their child to public school or a school, an alternative school, where the child is receiving substantially equivalent education, substantially equivalent to the public school in the district. So New York finally started doing something about this, and then we finally started seeing some cases. And a New York Supreme Court, which is the lowest court in New York, in 2022, held that these new regulations were unlawful because the Department of Education actually lacked authority to do what the regulation authorizes the department to do, which is to do an investigation of schools and to determine that some schools are not meeting the standards of compulsory education law, and to declare that those schools don't qualify as schools. And the regulation goes further, that the parents have to unenroll their children from those schools. Now, the court held that the agency had no authority to do that because the law doesn't apply to the schools. The law applies to the parents. Now, of course, it's going to be really difficult for the state to make a determination that parents are not complying with the compulsory education law by giving their child substantially equivalent education if the state doesn't have the authority to determine that the school at which the child is enrolled is not providing a sufficient education. So that's sort of a quagmire, but the lower court sided with the parents in that case. The intermediate appellate court then reversed, and this is now pending at the Court of Appeals, which is the highest court in New York. More recently, advocates on behalf of Hasidic schools filed a complaint with the Office of Civil Rights back in January. I haven't seen any updates to that. It could be that the Office of Civil Rights no longer exists. I don't know. But that's another sort of avenue where the advocates for the schools are claiming that the Department of Education of New York is discriminating against Hasidic schools by enforcing their regulations. Now, the reason I say this is a hard case, and I think also a fascinating case and an important case, is because it should, I think, push us to think more critically about this very tidy, neat line that Pierce established. And the compromise that Pierce reached, as I understand it, is that the state can have public schools. In fact, perhaps should have public schools. And the state can do what it wishes in the public schools. It has full control of the public schools. And the opt-out that parents have the right to is opting out of public schools altogether. And they have the prerogative to have private schools. Not to say that the state then has no control of private schools. The state still has some control of private schools, but not as much control as it would have if we were talking about a public school. And just 2 years after Pierce, in a decision that gets much less attention, Farrington, also decided by McReynolds, that dealt with a law out of Hawaii that pertained to schools that teach languages other than English and Hawaiian. And essentially, the regulations, the laws were just so draconian that the Supreme Court held in 1927 that that's de facto a public school. You can't call it a private, that this is, you have the right to go to a private school and then regulate the private school to such a degree that you have total control over it. This is a question that's pending, of course, the Supreme Court now with St. Isidore. What is a private school? What is a public school? But you have this compromise in Pierce that you can send your kids to a private school and the state can't regulate it too much, but it can regulate it somewhat. Barnett, around 20 years later, is picking up on one half of that ledger, which is this assumption that the state can fully control public schools. And Barnett, Justice Jackson and Barnett, which we also discussed quite a bit in the previous panels, said, not so fast. The state can't have quite total control in public schools. There are lines to be drawn. And it seems like the line, and this is something that Michael McConnell talked about, and as others have commented on, I think really fascinating, this idea that the school, my words, can't indoctrinate children, can't, to go back to language from Pierce, can't standardize children, can't have a unification agenda to render all children sort of too uniform. And I don't think that line is intelligible, workable. I like the principle of it, but I don't really know how it would work. And I think that the Mahmoud case, which we heard quite a bit about too, Mahmoud v. Taylor, is finally, about 80 years later, picking up where Barnett left off and pushing on some of the assumptions in Barnett that you can make these tidy distinctions between indoctrination and mere exposure. And it seems like, at least for some of the justices on the court, they're still clinging on to that distinction. And Justice Barrett in particular was asking a lot about this distinction and seemingly accepting it, that there's some kind of education that you could render indoctrination and some that is mere exposure. I don't, again, I don't think that works. I mean, one little piece of evidence is the colloquy from Mahmoud's oral argument between, and it really is a colloquy between the justices themselves, Justice Sotomayor and Justice Alito, and they are debating how to interpret a child's picture book for 4-year-olds. And I don't know how anybody could assume that statutory texts are sort of just plain meaning of statutory texts if these justices can't agree on a 4-year-old picture book and what it means and what it's trying to do. And for Justice Sotomayor, it's just telling you facts. There's a fact in Uncle Bobby's Uncle Bobby's wedding in that picture book, just a fact that this gay couple is getting married. And for Justice Alito, he says this is sending a clear moral message. Similarly, Justice Barrett and the advocate on behalf of the school talked about the difference between teaching the sheer facts in the world and trying to educate children to appreciate mutual respect of others. And that distinction seemed to collapse, I think, in that colloquy between Justice Barrett and Alan Schoenfeld. Okay, in any event, we have that sort of compromise in Barnett, and then you fast forward another 20 years roughly, and you get to Yoder. And this is now going back to the other side of the ledger in Pierce, so not focusing on public schools, but focusing on private schools. And the idea in Pierce that the state does have some control of private schools, some kind of minimum control of private school education. And in Yoder, the Supreme Court says, well, not so fast. At the very least, not with respect to 2 years of education for ages 14 to 16. Not even minimal control of compulsory education. And the reasoning in Yoder is that minimal education for those 2 years actually consists of indoctrination, at least in the eyes of the Amish community. For example, the language in Yoder is that this secondary schooling is exposing Amish children to worldly influences in terms of attitudes, goals, and values contrary to beliefs. And, Yoder often gets characterized as having been a debate about whether the children will attend public school. I mean, as a factual matter, that was true because the Amish community didn't have its own school. It was sending its kids to elementary public school, and then it pulled the kids out of public school. But that wasn't what was at issue. Pierce was still good law. The parents could send their kids to private school. They objected even to private high school education on the grounds that modern high school education teaches these values that conflicted with the Amish community's beliefs. And finally, and I'll end with this note, we can fast forward another roughly 50 years to our contemporary example that I started with the Hasidic community. And the Hasidic community, like the Amish, believe that secular modern education, even if we're talking perhaps about things like arithmetic, as factual as you could perhaps get, as neutral as you could perhaps get, as non-indoctrinating as you could perhaps get, for the Hasidic community, no, that is contrary to its way of life for a whole host of different reasons, which I won't get into now. And so now what? The envelope is simply being pushed further. And I'm not saying that I have the solution here. I don't. But I do think that drawing the line at indoctrination is not really helpful. And I'll end on that note.
Thank you. I'm going to start by asking the panelists to comment on one question, and then we'll open it up to everyone else. Pierce does recognize the right and perhaps obligation of the state to have some role in dealing with schools. And without using the term indoctrination, yesterday's panelists, among other things, talked about children's rights. What are the rights of children to receive an education that will allow them to function in the world as it is and to choose, if they want, to leave the nest of whether it be Catholic school, Hasidic school, private school, whatever the viewpoint is. So what are the minimum topics that a student should be, that the government ought to be able to say, this is required for citizenship, this is required to give children the education to which they have a right? And we'll just start down the line again.
Sure. I mean, I think that is at root a policy question, right? And different states may address that differently. But Pierce and Meyer give us a test for determining whether whatever the state says, X, Y, and Z goes too far, right? We know, number one, if you just look at the test in Meyer, the regulation, what the state is requiring, has to be within the competency of the state to effect, right? And that was the problem in Pierce. It was not within the competency of the state to standardize children, and that's why the regulations there, or the law there, was invalidated. In Meyer, it was a different problem. It's got to be within the competency of the state to effect, but the law must actually advance the interest that the government that motivated its adoption, and can't go further than reasonably necessary to achieve that interest. That was the problem in Meyer. The court explained it would be perfectly reasonable and perfectly constitutional if, rather than prohibiting the teaching of foreign languages, the state instead had required instruction in English. But that's not what Nebraska did. It took that further step of not just requiring instruction in English, but also of prohibiting instruction in any other language. So I can't say this is what the state can and can't require, but Pierce and Meyer themselves give us a framework for how to approach the question. And the other thing I would say to that is there's great uncertainty as to what the level of scrutiny is the court should be applying to claims brought under Pierce and Meyer. And unfortunately, the tendency of most lower courts has been to apply mere rational basis review, where judges can engage in conjecture and speculation about justifications that the court or that the state might have had for the law. And if it's reasonably conceivable that the law might advance that conceived justification, the court's required to uphold the law. That's no meaningful review at all. And so at a minimum, I think courts should actually honor what Pierce and Meyer taught in how to approach the question of how much regulation is too much. But again, what that is and where those lines are drawn, I think just varies case by case. So I couldn't say, it's got to be X, Y, and Z.
Eric?
So we're getting into areas that are outside my competence here completely, because when I look at these questions, I know that having a high quality education means a huge amount to individual students on average, that people who know more earn more, people who know more are in better positions. I know that countries where the population is better educated grow faster, and there are direct economic implications. How you translate that into law, I mean, I think I worry personally about what homeschooling is doing to children that whose parents are not prepared to get them ready to operate within society, and most states don't require that. And then the sort of trade-off of rights is something that's beyond me to think about. I'm thinking about more from the economic and social value of better education, and how the rules and rights regulations we put into effect impact on the quality of our schools, which need help.
Zelda?
I mean, I'm very deeply sympathetic to drawing the line there and saying that the minimum and maybe also the maximum is to ensure that children can exit the community into which they're born and raised, so they have choice. So thinking about the choice of the children, the autonomy of the children, not just the autonomy of the parents or the autonomy of the community, very sympathetic. At the same time, I don't think that you can avoid the claim, if somebody were to want to make it, that the state is indoctrinating, even if it's indoctrinating into autonomy, which itself is obviously very value added. There's no way to escape that. I think actually there's really interesting. I talked about a colloquy in Mahmoud. There's a really interesting colloquy in Yoder between Douglas and Berger, and Douglas gets a lot of attention, but I don't think Berger's response to Douglas gets much attention at all. And I think he has a really terrific point. I don't know how far he would actually take it. Again, in Yoder, we're talking just about 2 years of education, not elementary school or middle school. But at one point, in response to Douglas, who says, talking about opting out and opting, perhaps also talking about opting in, Douglas says the children have to affirmatively opt into Amish life. And that means to say affirmatively opt out of compulsory education, secular modern high school education, for a court, such as ourselves, Douglas is saying, to uphold the parents' rights, and you could also say the community's right, against the state that wants to enforce its compulsory education law. In response, Berger says, and I'll just read to you, it seems clear that if the state is empowered as parents patria to save, in quotation marks, to save a child from himself or his Amish parents by requiring an additional 2 years of compulsory formal high school education, the state will in large measure influence, if not determine, the religious future of the child. And I don't know why that wouldn't extend even to elementary school. And certainly that's what
would
the
it
community would.
extend to secular private schools? That rationale would seem not the same.
Sure. And I think if the problem is to go back to Pierce, is standardization of children, uniformity. If that's the problem, well, so long as you have a compulsory education law that applies to all children, you have standardization. Even if we're talking about secular school, I don't think it's avoidable.
Could I add one little caveat to what I said, or sort of reinforcing something that Michael said in his introduction? And that is, when you look at school choice, and I say that I'm in general in favor of more school choice in all kinds of ways, the opposition to school choice is not about what's happening to the kids. It's about the um, uh, teachers' unions and other organizations that like the current structure of traditional public schools and want to stop any alternative in competition. And so that's not in my world ever phrased in terms of the rights of kids or parents or this balance. It's that from a policy standpoint, I want to pay attention to what kids can learn and do learn. And most of these debates about school choice are not about that at all.
Yeah, and I think it's interesting that you're right, that oftentimes these cases are brought by the state teachers unions or at least funded by, and I would encourage them to take a look at their own schools. I mean, how do we assign children to public schools in this country? The overwhelming majority of kids are assigned by nothing more than their residence, which is just a proxy for wealth. I think that's a profoundly dumb way to determine a child's education. And of course, the wealthy have choice, right? They can move to a different zip code that has a better performing public school. They might be able to pay tuition out of pocket at a private school. But the vast majority of children in America attend public schools that they are assigned to by the government based simply on where they live. And so if the public school establishment, the teachers unions and such, were truly concerned with ensuring that every child could get access to the best education, they would not be defending that means of assigning children to public schools.
And they wouldn't send their kids to the other public schools.
We'll take questions from the audience. I see Robert Post lining up.
Thank you to the state. They have a question and a comment for each of you. Judge Graber, you commented on a shortness of Pierce and Meyer. The average staff court opinion was 6.2 pages. The average McBale's opinion was 4.3 pages, sir. Different row. Now, Michael, to you, on your last was how do you deal with the decisions of the court in Rust versus Sullivan and taxpayers versus Reagan? It wasn't clear to me and get around those precedents. Eric, to you, you invoked the name Manuel Friedman, which apparently am a policy people's equivalent to invoking Pearson Buyer, where it's authority. And my question is, Monroe is Friedman is cited for the fact that competition produces effectiveness and excellence and the achievement of some kind of efficiency. So, what is the metric of success that competition is supposed to produce? Are we measuring success by consumer satisfaction, where I understand the concept of competition, consumer at the child, consumer of a parent, or do we measure success by the implication of cognitive capacities testing? Where do we measure success by performing a social function like citizenship and civic education? How exactly does competition relate to a metric of success? And what is the metric of success once you do that? And it's on the, isn't, wouldn't the answer to that question, what is the criterion of success for public education, be a guide to the Diener Court of Appeals and your kicks, rather than does the child have rights or does the parent have rights, to ask what is the function of education, constitutionally speaking, in the state of New York, and does the 2006 was meet that criteria? We'll stop.
Okay, so on the question of cases like Rust and Regan, those same arguments were made in Carson. The United States flipped sides during the course of the litigation, supported us at the district court and appellate court, and then there was a change in administration, argued at the Supreme Court that Maine's justification or that Maine's exclusion of religious schools was permissible, and they raised primarily those two cases. And the bottom line is that, well, number one, Rust, although the court didn't describe it in Rust itself, has subsequently described Rust as a government speech case, right? And I know that's debatable, but the program in Rust was funding a particular message for a particular purpose to the exclusion of all other messages, right? That's one thing to note about it. And the providers in Rust were free to engage in those other things. They just couldn't use the funds for that purpose. In Maine, on the other hand, the government wasn't funding one particular thing to the exclusion of all others. Maine was saying, here's a voucher. You can use it to attend a public school in a neighboring district. You can use it to attend a private school in Maine. You can use it to attend a private school in another state. You can use it to, and kids did use it to attend private schools in another country. The one thing you couldn't use it for was religions. That is very unlike Rust, right? So I think that's one way to distinguish it. And of course, a child, unlike the providers in Rust, could not simultaneously get the benefit and still exercise the fundamental right. You couldn't exercise your right to send your child to a religious private school and then also get the tuitioning benefit, the voucher, to send your kid to a non-religious school for, another 8 hours a day. So I think there are differences between Rust and Regan, but those are precisely the two cases that the United States in its amicus brief raised, and the Supreme Court wasn't convinced.
I just suggest that Carson is a little like what we call pre-expression land, a limit of reform. And your description of Alaska didn't sound like that.
So correct. In Alaska, so limited public forum. Well, I mean, the court in.
We owned it out to everybody except.
I see. So yeah, I mean, and the forum, like interesting questions about forum analysis. Of course, in Locke versus Davey, the court says a scholarship is not a forum for speech. But yes, in Alaska, the legislature opened this program up to basically any educational expense whatsoever, and then
all private.
No, the legislature did authorize it for use at private school tuition. The plaintiffs, the Alaska Education Association, or at least the plaintiffs that they were funding, came in and said, whoa, hold on. Homeschooling might be okay. Tutoring might be okay. Textbooks, curricular materials, that might be okay, but not tuition for a private school. And so the legislature, in its discretion, wanted to provide a benefit that all children could use for any legitimate educational expense. And it was the plaintiffs saying, well, everything except this one thing. So in that respect, it's very much like Carson.
Okay, Eric?
The metric of success is there are multiple metrics of success. The one that would apply most directly to Milton Friedman and competition would be that you get more efficient production of student learning, and so that we know since 1965 till today, expenditures per pupil have over quadrupled in real terms, and by all measures of performance, there's been no change in performance. So it would be hopefully that you get a little bit more value out of the added funds that we've put into schools. It's obviously broader than that, but the state also has an interest in the quality of its labor force, because states the growth of economic activities in states and activities depends upon the quality of the labor force. And so I would hope that competition pushed you in that direction and that policy pushed you in that direction. Test performance would be high on my list. I'm not trying to say that's the only performance. I mean, obviously, the civic values and others would be important, but I see no evidence that, except for maybe the Hasidic community, that you get dramatically lower civic values out of private schools versus traditional public schools.
Zalman?
So orthodoxy and test results.
I mean, you absolutely could draw from the metrics that you use in a public school setting, but you have to ask what the metric is of the metric, right, to determine what the metric is. So inputs versus outputs, it might inform that decision. And the Hasidic community is arguing, actually, for example, that, wait a second, our children are in school. Let's just be clear. In fact, they're in school for more hours probably than most public schools. And the Hasidic community comes back somewhat on the offense, not just defense, by saying our kids are getting great trainings. Look at all the critical reasoning skills that they develop, etc. They are very literate. They're learning to read. They're not really learning to write, but okay, arguably they are to some degree. And so these should be the metrics. And then you have a debate about the metrics, which will be informed by the metric of the metrics, which is why the children's rights might matter. If the children's right is to have the ability to exit, you can't exit into nothing. Your exiting also includes entrance. And so to enter into the broader secular world, you probably need certain skills beyond just great critical reasoning skills, including, for example, English, other cultural references, etc.
Okay, Gene?
Yeah, so I want to also bring us to a pre-expression and like Robert, although maybe more kind of more thoroughly. So, I'm a free speech guy, so I think everything is a free speech issue. So I think that if you just apply standard free speech doctrine, you get some answers, and maybe they're the wrong answers, but here's some possible answers. So one is, what about the government attaching conditions to the spending of money? We know when the government says, here's some money, it could attach conditions, and those conditions set aside the question whether the Alaska tax scheme is permissible. Assume it is spending money on private schools. It can say, look, we want to make sure that you teach certain things, and it can generally do that, even when it's promoting a wide range of private speech, if it's reasonable and you could pretty flexible. With some respect, so viewpoints. But when it comes set aside the conditions on spending, generally speaking, the government has to show some very, very substantial justifications. And my sense is what we're really talking about is not so much the duties of private schools, but the duties of parents. So the sense is parents have an obligation, under some of ought to have an obligation to teach their children certain things, certain kinds of content. And that obligation is something they can discharge through sending them to compliant public schools or through homeschooling, or perhaps sending them to non-compliant schools supplemented with necessary private school. It would be so that Hasidic parents were sending routinely their kids to Hasidic schools, but were also uniformly providing English language training as adequate. Well, we might say that's fine. So then the question is what conditions are permissible. You might say something like strict scrutiny. You could imagine a plural scrutiny, but you funnel it through that and you'd ask, what does the government have a compelling interest in? So I think probably has a compelling interest in making sure that children are basically literate and numerate. And if that's so, then I think that satisfies in large measure the exit concerns. And also, I think that pretty compelling interest looks like a requirement, certain requirements by the narrowly tailored values. What about some other things? What about teaching evolution? I think evolution is a tremendously important scientific concept. I think it's really good for kids to learn it. I don't think there's a compelling government interest to make sure that our child learns it. Whether you look at it from the perspective of national benefit or you look at it from the perspective of exit, because if you do want to exit if like I'm a biologist, you better know evolution, but you can look it up, right? There are books that will tell you all about it, possibly better than the mini classes teach. No, you really want to let it. So why wouldn't that be a pretty sensible way that provides considerable light for the government as the things that are really critical, but at the same time recognizes that it's a pretty serious thing to say to parents, you must speak to your children, either yourselves or through a school about certain things. And that's something we reserve for these that are genuinely necessary, as opposed to what we think a good, urbane, thoughtful, even high person on.
Anybody want to comment?
Yes, it's a yes, and that I would certainly support the argument that the government has an interest in kids being literate and numerate, and that ought to make that something that's high on the list.
Nomi?
Hi, and thank you all. I might ask about the role that quality is playing in this debate. Actually, two questions. So first of all, this one you observed that securing public funding for religious education needs be any follow. Is that the study inherent tension between that agenda and fulfilling some principle of equality, but the movement to secure public funding for religious education, be it in private schools or homeschooling, privileged academic public schools, has been joined and framed as an equality agenda. And there's actually two distinct principles or versions or conceptions of equality that I think could get played. One is this idea that distinguishing between religious as opposed to non-religious anything, people, activities, schools, is in and of itself a form of discrimination that violates the principle of equal protection and so on and so forth. And that's one of the principles of equality that is being relied on here. And one question I have without that, this is one of my two questions, is if we accept that conception of what constitutes implicit discrimination, having worked at equation, but the Establishment Clause itself is not violating that principle. So that's question number one. But my second question has to do with this other principle of equality that I think plays a very powerful role, certainly in lending a lot of moral force and appeal to the parental choice movement. And that has nothing to do with the distinction between religious and non-religious anythings. It has to do with economic inequality. Many people yesterday and today have adverted to the ways in which this is really an issue of distributive justice, and how those who lack the economic means to be able to exercise the right established in Pierce are maybe not legally coerced, but are economically coerced, right? There's been a lot of that kind of language. And I imagine virtually all of us resonate to that concern. But it just strikes me as an incredible mismatch of solution to problem. If the problem is a problem of distributive justice, of economic injustice, of economic inequality, of of the incredible disparities in the quality of education and schools, and the way in which those inequities and those differences in the quality of schools perpetuate economic disadvantage. That's a problem I think many of us would want to solve. To think that parental choice is an adequate solution to that seems so questionable to me. It seems at best a all that you could achieve at best is expanding the circle of parents who can exercise their right to opt out of schools. For all kinds of reasons that I'm not going to elaborate, there's a lot of parents who are going to be unable to use whatever it is, an education savings account, a voucher, direct funding to religion. That's just not going to deliver to all or even most parents the means to be able to exercise the right. And even amongst those who are sort of endowed with the means to exercise their right, as you said, Eric, it's a smaller subgroup of them who are going to end up placing their kids in schools that are actually better. But the bottom line is we're still going to have better and worse schools. We're not going to be solving the equality problem. And I guess when I think about it, I can't help but feel like there's a kind of sleight of hand going on in the rhetoric, whereby the case for private choice and the case for the Constitution, not just the constitutionality, but the constitutional necessity of the kinds of programs you're defending, it's being rooted in this notion that this is how we're going to vindicate or overcome the problem of economic disadvantage, when it will not, and arguably actually might make the problem of economic inequity worse.
Does anybody want to comment?
I don't think that was directed at me, so I'm not.
You don't have to comment.
I'm
It's
kidding.
okay to just have a conversation.
No, I mean, I don't disagree with you that there are systemic problems that school choice is not going to solve. I don't pretend to think that school choice is the panacea that's going to improve public schools, that's going to end economic disparity. But I look at it through the view of parents, right? I'm not against public schools. The solution from people that see this differently than I do is often more money, right? We don't fund schools sufficiently. Give us more money. That will yield better results. I don't think that's necessarily true, but I'll indulge the argument. You still have to ask the question, when? 2 years from now? 5 years from now? 10 years from now? The problem is there are kids who are trapped in failing schools today, right? Those kids can't read today. Those kids can't write today. The promise of reform that might yield results at some point in the future does nothing for those kids. Giving that child a scholarship so that they can get out of a failing environment today and into an environment where they have a shot at success today does do something for that child. That's my concern. Yes, we still need to address all of those other things you mentioned, but my concern is ensuring that children today can access the education that they need.
Thank you. We have time for 2 more questions, and I see 2 people in line. We'll start with Rebecca.
Thanks, Judge. I had a question, Michael, about, you alluded to unconstitutional conditions doctrine, and I agree with you that that's what's really doing the work in like Espinosa and Carson. And you sort of said, now, of course, this doesn't mean they have to fund private schools. But for me, I don't see where the limits of that logic are. I think that the next step is, well, if you choose to provide public schools, then it's an unconstitutional. So I'm curious why.
That next step is now.
Yeah. So I'm
That's it.
curious why you think that's a tenable line.
Sure. The government can operate a public school system and not have private school choice. I don't think there's anything unconstitutional about that. The government can do a couple of things, though. The government can't fund any and every educational expense, whether it's homeschooling, tutoring, etc., and then single out the one thing, right?
I know that's your
Okay.
argument in the
Right.
Browser case. I'm asking you to.
Sure. And the other thing is that I don't think a state can do is enshrine a prohibition against a particular type of education in its state constitution. So yes, Alaska could just operate a public school system and not fund private alternatives, but Alaska has enshrined. Okay,
But that, well, you're just asserting, you keep asserting they, of course they can't. And then you try to go back to your case about vouchers. But I'm just trying to say, why do you say of course? Because if you extend the logic, public schools could also be considered.
government
Uh,
choosing
on-
not
per-
to do. Sure, I just use a different government choosing not to do something from government saying under no circumstance may the legislature in its discretion do the something, particularly when under no circumstance, when the thing that under no circumstance may the legislature do is defined by a fundamental right? Of course, we would not countenance a state constitution that said, no public benefits for people who exercise the Fourth Amendment right or who criticize the government. Like, we would never countenance that. But that's precisely what a provision like Alaska's does. Right? I'm sorry if I may not be.
Okay, we'll leave the last question if you're in line.
Can I say really
Paul
quickly,
Peterson.
and
Yeah.
Rebecca's point, I agree with you completely. And I think this, Saint Isidore, which I think we touched on a little bit, is getting at exactly that question. And there's all this formalism in the briefs and oral argument. Is it a public school or is it a private school? And it has to fit under one of those two. And what is a public school? As if there's some universal, objective, inherent answer to that question. And of course, there isn't. The bottom line, and Justice Kavanaugh in oral argument, I think Rebecca and I talked about this a little bit yesterday, described what the state is doing, Oklahoma is doing, as rank discrimination. To your point, which is if you have a public school and you're not having also a public religious school, call it whatever you want, that ostensibly is rank discrimination.
Okay, last but not least.
Okay, I don't like this courtroom atmosphere. This idea that you got to speak to the high court all the time and the rest of the people out here don't count for anything. I reject.
Court is not in session.
So, my view of it is the Declaration of Independence says that, America is about life, liberty, and the pursuit of happiness. And I think we've forgotten that. And for me, liberty is at the center, not only in that phrase, but at the center of the American political tradition. And so you really have to ask the question, is liberty really seriously interfering with all of the other good things that people are concerned about? Equality, economic prosperity, economic growth, higher test scores. Is liberty really interfering with that? And yes, the hard case from New York is really an interesting case because it's a very hard case. But I ask myself, okay, so if we're going to have liberty, we have to allow the Amish to do what they want to do. Even though we sort of think that maybe it's foolish to do that. And maybe the same is true for the people who live in Queens or Brooklyn or and attend Yiddish schools. So there will be foolish choices made. When I look at the fact that there are many, many children going to absolutely horrible public schools and are suffering very badly from that, I wonder whether or not those Hasidic kids are suffering anymore. So I think you can find these horror cases, or take homeschooling. You can find some horrific examples of homeschooling. But if you look at the practice of homeschooling in general, does it produce outcomes that are systematically inferior to what you find in our public school system? And if you look at the adults who say that they had been homeschooled as a child, and you get a random sample of them from across the country, you find they pretty much look like everybody else. They have about the same income, same education, same tendency to socialize in public and have friends and neighbors and have happy lives and so forth. They're not any better. It's not like, homeschooling is going to be the solution to the problem. Or take charter schools. It's very hard to show that kids who go to charter schools are doing much worse than kids going to public schools. They're about the same, really. I mean, maybe a little better, but it's not all that clear. Or you take the kids that go to private schools and you adjust for how much the family brings in terms of family background, and you don't see that the private schools are doing that much better. So in the end, it's not about how do we create the best educational system. It's about liberty. Let people choose. To me, that's the fundamental question.
Thank you.
But I want to turn this over to the panel because they may have a different view.
Okay.
I'll just say,
At the end of our time, but I'd like to give
say-
everybody one
very
last
briefly,
chance.
very briefly, that I think you can be relativistic about education, just as you can be relativistic about anything normative. That much I agree with. But to say that liberty is the answer, I don't think does much for the problem, because you're focusing on a particular group's liberty. You're focusing on the parents' liberty. Maybe you're focusing on the community's liberty. You're not focusing on the children's liberty, or at least let's say their future liberty, which would require a very sort of robust understanding of liberty, which itself is quite indeterminate. So I don't think liberty helps much.
We spend $900 billion a year on K-12 education, public K-12 education in the U.S. I would like it to be spent well in terms of providing opportunities for students and for the nation. And I view many of these questions of school choice not as in terms of liberty or in terms of rights, but in terms of is it providing better education, the possibility of better education for a certain subset of students, and by providing that education, could it also help the other $900 billion to be used more effectively? And that's mine is not, probably shouldn't be discussed in a legal constitutional forum. But that's my concern, that we're not doing very well with our public schools, no matter what.
Michael, last word.
Last word. I would just kind of echo what Professor Peterson was just saying about the kind of courtroom atmosphere in here. All of us, I think, want the same thing, which is children to have access to the education that is going to be best for their children. Obviously, we disagree very, very vehemently about how best to achieve that. But I appreciate you all hearing me out. And for those who don't disagree, I at least hope you understand that I want the same thing that I presume you do as well. So thank you for
Many thanks to our panelists.